Mr. Hill, Thad, we laid on your desk there an amended D5. We're back on the record on jury instructions. When we left on Friday, I gave the defense an opportunity to comment further on S3, dealing with the timing of the robbery versus the alleged killing versus alleged robbery, whether the intent to rob had to be formed prior to the alleged killing. I was the opinion that as long as it's a continuous transaction, it didn't matter, and advised the defense that's what the court's opinion of the law was, and gave it an opportunity to provide me with any law that rebutted that. I didn't receive any, so I'm working under the assumption that you doesn't have anything to rebut that theory, that statement of the law. I'll let you make any arguments that you want at this time anyway.
They haven't proven a robbery. They haven't proven
I think that's a question for the jury. I just get into the law. The jury gets into the facts anyway. As to, there's testimony of what property was traditionally in the possession of the defendant, Mr. Carpenter, and what was no longer there anyway. And I think that that's a jury question whether there was a robbery or not anyway.
Yes, sir.
All right. All right. I'm going to give S3, which says, court instructs the jury that the state is not required to prove the defendant had the intent to rob Kirby Carpenter prior to the killing to support a conviction of capital murder with the underlying felony of robbery. It is sufficient for conviction if the state proves that the crimes murder and robbery were connected in a continuous chain of events. Intent to commit the robbery may be inferred by all the circumstances surrounding and connected with the killing of Kirby Carpenter. I'm going to give at S3. We also left here Friday with the question of whether the defense was entitled to an alibi instruction. I think at that time there was a D1, D2, and D5 that all dealt with alibi instruction. The court's opinion that is the defense theory of the case, and the defense is always entitled to an instruction on its theory of the case if there's any evidence, even more, regardless how scant, that supports the instruction. So I'm going to give an alibi instruction. We're down to which one of these instructions that I'm going to give. We had some emails yesterday, and the state was objecting to the first paragraph of D5, and I've taken the liberty of, and I agreed with that, and took the liberty of deleting the first paragraph of D5, so we're down to D1, D2, and an amended D5. The defense has indicated they want alibi instruction, and they are entitled to a alibi instruction. We're just arguing over which one it's going to be now. Mr. Hill, I'll give you an opportunity to express which of the three you think is the appropriate instruction. I'll give the defense state an opportunity to express which they feel is an appropriate instruction, and then I'll make a decision. If y'all would, tell the jury we're out here working. We're not just drinking coffee and eating donuts, even though I have been eating donuts. Good morning, young lady.
Good morning.
I'm going to maintain my position for the record that D5, as we submitted it last week, is appropriate, it's accurate statement of the law, and that's the one that we prefer.
Let me, Lynn, did you have that original D5 that she got me a copy coming here?
Sorry.
I think the first paragraph of D5 has been more than adequately covered in at least 2 prior instructions. So I don't think that the first paragraph is necessary, and I'm going to refuse D5. The
Is this the
original.
one that you're giving instead?
Do what?
Is this the one you're giving
That's the one
instead?
I'm proposing without the first paragraph. And so you have your position on D1, D2, or that amended D5 that you've got there without the first paragraph.
Well, I prefer my original that I submitted last week, but
I understand that.
I will accept the one that I have in my right hand.
Okay. You're going to get one.
Yes, sir.
Either D1 on Alibi, D2 on Alibi, or D5 on
I
Alibi.
prefer your amended version.
On D5?
Yes, sir.
All right. State had any objection to giving D5 in lieu of D1 and D2?
No, sir.
All right, I'm going to give D5 then as amended. I thought that was the most succinct statement of the law. All right. So I'm going to go over the instructions that the court is proposing to give, and if you've got any objection, and I'm going to give them in the order that I'm putting to call them out anyway. Court's going to give court's instruction 1, court's instruction 2, court's instruction 3, court's instruction 4, court's instruction 5, court's instruction 7, defendant D4, D5, S3, S2, and I'm going to conclude, last instruction will be S1, the elements and the form of the verdict. And other than any objections already raised, is there any objections to the court's instructions that I'm going to give?
Nothing to say.
Nothing more than what I've already.
All right. Is everybody ready to bring the jury in?
Yes, sir.
And I believe you said we're going to have an hour for each side have an hour for closing statements. Do you want me to give you a warning on 30 minutes, or you just want to talk till you're tired?
I'd rather just keep going.
Do what?
I don't think I'm going to say 30, but
I'll give you a 2-minute warning on 30. How about that? Mr. Hill, would you like a warning on your hour?
Maybe 5 minutes, but I'm not going to take it.
Okay. Give me just 1 minute to gather some stuff. I'll be right back. Y'all be getting your jury ready to come on in, okay? When the jury gets out, I'll spend about 10 minutes reading the jury instructions. The state will then have... I'm sorry. Go ahead. You need me to...
I interrupted her. Could you keep going?
Okay. Be prepared to sit for about 40 minutes. We'll have a little, if you need a little break then, you want to leave at that time, you can. Then be prepared to sit for about another 45 minutes to an hour. I don't want anybody coming and going when the attorneys are making their closing arguments. So, and then you'll have about another. So don't get up and leave during the closing arguments. And Mr. Bailiff, once they start their closing arguments, don't let everybody come in until they have a break, okay? I don't want to be any eruptions, all right?
Your Honor, I'm missing an exhibit.
I didn't get it. I
Okay.
promise.
36.
36. 36 is, it's been omitted. Safety box, easement and log, Saltville branch. You find it?
It's at the very bottom.
I knew it was going to be there.
All right, hold on.
Miss Kathy's in charge.
Miss Kathy, what?
You was in charge. I know you had your stuff together. Let's. I want to talk. Y'all come up here and approach Thad or Ben or somebody. I'm not rushing anybody, but are you ready? Which is sort of like rushing you.
We're ready.
I need to lay my hands on a couple of exhibits.
Let me do this. Let me give you an opportunity between the state's closing and your closing, okay? Jerry's been waiting long enough.
Yes, sir. Thank you.
And I'll have these instructions available if you want to use them in your closing, okay? All right, show the jury in if you're ready. I believe you got to stand, Mickey, so everybody can see you. If you would, okay. All right. Look like everybody survived the weekend. Good morning, all. Had some good football games. Some turned out the way I wanted, some turned out the way I didn't want anyway. I trust no one had any problems with the court's instructions not to investigate the case, not to discuss the case, not to form or express any opinions about the case. If you've had any problems in that regard, let me know. If not, if you don't let me know, I'm assuming you haven't. All right. At this time, what I'm going to do is I'm going to read you the instructions of law, what the law is. As I told you, if we started this thing, I get to decide what the law is. Y'all decide what the facts are. After I've read the law to you, the state will make its opening, closing arguments. And then the defense will make its closing argument. And because the state bears the burden of proof, they'll get the last bite at the apple and have the last closing argument. So pay attention as I read these rules to you. Members of the jury, you have heard the testimony received, the evidence introduced in the course of this trial. The court will presently instruct you as to the rules of law which you will use and apply to this evidence in reaching your verdict. When you took your place in the jury box, you made an oath that you would follow and apply these rules of law to the evidence in reaching your verdict in this case. It is therefore your duty as jurors to follow the law which I shall now state to you. On the other hand, it is your exclusive province to determine the facts in this case and to consider and weigh the evidence for that purpose. The authority thus vested in you is not an arbitrary power, but must be exercised with sincere judgment, sound discretion, in accordance with the rules of law stated to you by the court. Both the state of Mississippi and the defendant have the right to expect that you will conscientiously consider and weigh the evidence and apply the law of the case, and that you will reach a just verdict, regardless of what the consequences of such verdict may be. It is your duty to determine the facts and determine them from the evidence produced in open court. You should not be influenced by bias, sympathy, or prejudice. Your verdict should be based on the evidence and not upon speculation, guesswork, or conjecture. You are the sole judges of the facts in this case. Your exclusive province is to determine what weight and what credibility will be assigned to testimony and supporting evidence of each witness. You are required and expected to use your good common sense and sound, honest judgment in considering and weighing the testimony of each witness who has testified. Although you are the sole judges of facts, you are duty bound to apply the law as stated in these instructions to these facts, that you find them from evidence before you. You are not to single out one instruction alone as stating the law, but you must consider these instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law. Regardless of an opinion you may have as what the law ought to be, it would be a violation of your sworn duty to base your verdict upon any other view of the law than that given. Arguments, statements, and remarks of counsel are intended to help you understand the evidence and apply the law, but are not evidence. Any arguments, statements, and remarks having no basis of evidence should be disregarded by you. The evidence which you are to consider consists of the testimony of the witnesses and the exhibits offered and received. Production of these evidence in court is governed by rules of law. From time to time during the trial, it has been my duty as judge to rule on the admissibility of evidence. You must not concern yourself with the reason for the court's rulings, since they are controlled and governed by rules of law. You should not infer from any ruling by the court on these motions or objections to the evidence that the court has an opinion on the merits favoring one side or another. You should not speculate as to possible answers to questions which the court did not require to be answered. Further, you should not draw any inferences from the contents of those questions. You are to disregard all evidence that is excluded by the court from consideration during the course of the trial. You are not bound by any rules of parliamentary procedure in your organization or in your deliberation. But the court suggests that you choose a person to speak for you. You may vote on your individual beliefs either by show of hands, secret ballots, or any other method you choose. If in stating the law to you I repeat any rule, direction, or idea, or if I state the same rule in a different way, no emphasis is intended, and you must not draw any emphasis therefrom. The form of your verdict is suggested in another written instruction or instruction. Your verdict may be in one of the suggested forms. It should be written in the handwriting or printing of one of the individual jurors on a separate sheet of paper furnished to you for that purpose. None of the individual jurors has to sign your verdict. The order in which these instructions are given to you and the manner in which these instructions and exhibits are numbered has absolutely no significance. You will have with you in the jury room all the papers and evidence applicable to this case. Although during the trial other papers, documents, exhibits, or charts may have been mentioned to you, once you have entered the jury room for deliberations, no other documents, papers, exhibits, or charts may be given to you. Transcripts of the trial testimony or parts of the trial testimony are not available. When you enter the jury room for deliberation, the court suggests to you that you discuss the facts of the case and review these written instructions before you begin voting or attempting to decide the case. The burden of proving the defendant guilty of every material element of the crime with the defendant is charged is upon the state of Mississippi. The law makes no distinction between direct and circumstantial evidence, but requires that before you can return a verdict of guilty, the state of Mississippi must prove beyond a reasonable doubt that the defendant is guilty from all the evidence in the case. The law presumes every person charged with the commission of a crime to be innocent. This presumption places upon the state of Mississippi the burden of proving the defendant guilty beyond a reasonable doubt. The presumption of innocence attends the defendant throughout the trial, and prevails at its close unless overcome by evidence which satisfied the jury of his guilt beyond a reasonable doubt. The defendant is not required to prove his innocence or to offer any evidence at all. The verdict of the jury must represent the considered judgment of each juror. In order to return a verdict, it would be necessary that each juror agree thereto. In other words, all 12 of you must agree on a verdict in this case. It is your duty as jurors to consult with one another and to deliberate in view of reaching an agreement if you can do so without violence to your individual judgments. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion, if convinced that your previous opinion was erroneous. But do not surrender your honest convictions as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning their verdict. Upon retiring to the jury room, you will select one from among your number to act as a foreperson. The foreperson will preside over your deliberations and will be your spokesperson before the court. If it becomes necessary during your deliberation to communicate with the court, you may send a note by the bailiff. During deliberation, no member of the jury should ever attempt to communicate with the court by any means other than a writing, and the court will never communicate with any member of the jury on any subject touching the merits of the case, otherwise in writing or orally here in open court. Bear in mind also that you are never to reveal to any person, not even me, how the jury stands numerically or otherwise until you have reached a verdict, unless asked by me in open court. Notes are only a memory aid, and the jury's notes may be used only as an aid to refresh that particular juror's memory and assist that jury in recalling the actual testimony. Each of you must rely on your own independent recollections of the proceeding. Whether you take notes or not, each of you must form and express your own opinion as to the facts of the case, and the individual jurors may be used by that juror only and may not be shown to or shared with other jurors. Jeffrey Dean Spence has entered a plea of not guilty. This means that you must presume or believe Jeffrey Dean Spence is innocent. This presumption of innocence stays with Jeffrey Dean Spence throughout each stage of trial unless the presumption has been overcome by evidence that satisfied the jury of Jeffrey Dean Spence's guilt beyond a reasonable doubt. Jeffrey Dean Spence is not required to prove his innocence. Jeffrey Dean Spence is not required to present evidence or prove anything. Because Jeffrey Dean Spence is claiming an alibi for his defense, that is, he was elsewhere on the date and time of Kirby Carpenter's death, the state has the burden of proving beyond a reasonable doubt that Jeffrey Dean Spence was not elsewhere at the time of Kirby Carpenter's death. The court instructs the jury that the state is not required to prove the defendant had the intent to rob Kirby Carpenter prior to the killing to support a conviction for capital murder with the underlying felony of robbery. It is sufficient for a conviction if the state proves that the crimes murder and robbery were connected in a continuous chain of events. Intent to commit the robbery may be inferred by all the circumstances surrounding and connected with the killing of Kirby Carpenter. Robbery, as referenced in these instructions, means that the state proved the defendant unlawfully, willfully, and feloniously did take from Kirby Carpenter or from his presence his personal property with the intent to permanently deprive Kirby Carpenter of the property, and this was done against Kirby Carpenter's will by violence to his person or putting him in fear of immediate injury to his person by the exhibition of a deadly weapon. The defendant, Jeffrey Dean Spence, has been charged with a felony crime of capital murder. If you find beyond a reasonable doubt from the evidence in this case that Jeffrey Dean Spence, on or about the 30th day of November 2022, in Tippah County, Mississippi, y'all approach.